Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an update from the 9-judge Constitution Bench of the Supreme Court, which on 25th July this year by an 8:1 majority held that states have the power to levy tax on mineral rights and that Mines and Minerals Development and Regulation Act does not limit such power of the states. After the judgment was pronounced, the union and certain assessees made a demand that the judgment should be given only prospective effect. Following that, the 9-judge bench held a hearing on this particular aspect on 31st July. And today, the judgment on this aspect was pronounced. As per the verdict, the top court has rejected the argument that its judgment delivered on 25th July should be applied only prospectively. It said that states can recover past tax dues on mineral rights, but with respect to transactions after 1st April 2005. This means that the court has allowed the states to recover the tax dues for the past period based on the judgment in Mineral Area Development Authority versus Steel Authority of India. The court also stated that the tax arrears can be paid over a staggered period of 12 years from 1st April 2026. The court further stated that there should be no levy of interest or penalty for the demand made for the period before 25th July 2024, that is the date of the judgment delivered by the Constitution Bench. CJI D.Y. Chandrachud explained that the court has taken the financial year after 2004 judgment in State of West Bengal versus Kesoram Industries, which upheld the power of states by overruling a previous judgment as the cutoff. The CJI also said that the present order will be signed by only 8 judges, as Justice Nagratna had dissented in the original judgment of 25th July. To read about this in detail, you can visit livelaw.in. In the next update, the Supreme Court has today issued notice on the petition filed by Delhi Chief Minister and Aam Aadmi Party Chief Arvind Kejriwal seeking bail in the case registered by CBI in connection with the alleged Delhi liquor policy scam. A bench of Justices Surya Kant and Ujjal Bhuya also issued notice on another petition filed by Kejriwal challenging the arrest by CBI. You are aware that Kejriwal was arrested by CBI on 26th June this year while he was in ED's custody. Weeks later, on 12th July, the Supreme Court granted him interim bail in the money laundering case while referring his petition challenging ED arrest to a larger bench. But he continued to remain in judicial custody due to his arrest by the CBI. Though he challenged the CBI arrest and sought bail before the Delhi High Court, his petition was dismissed. Therefore, he has now approached the Supreme Court. Today, his counsel, Senior Advocate Abhishek Manu Singhvi, submitted that he got interim bail on 3 occasions in the money laundering case despite stringent rigors of Section 45 of PMLA. He wondered, when Kejriwal got bail under the stringent provisions of PMLA, how could he be denied regular bail in CBI case since Prevention of Corruption Act does not have stringent conditions similar to the money laundering law. He termed the arrest by CBI as insurance arrest, which was made on the cusp of Kejriwal's release in the ED case. When Singhvi pointed out that Kejriwal has also sought interim bail, the court denied to grant any interim bail. The bench has posted the matter next week on 23rd August. And now coming to latest development in the Byju's insolvency case. The Supreme Court today stayed the order of National Company Law Appellate Tribunal, which closed the insolvency proceedings initiated by Board of Controllers of Cricket in India, that is BCCI, against edtech firm Byju's over the dues of 158 crores. You must be aware that Byju's, a well-known Indian edtech company, faced financial difficulties following reopening of schools post-pandemic, which led to a decrease in demand for its online educational services. Byju's had a deal with BCCI to advertise on cricket team jerseys and get match tickets. They agreed to pay a certain amount for this. However, Byju's failed to pay the full amount, owing 158 crore. Despite having a bank guarantee, they did not clear the debt, leading to financial troubles and legal action against them. Earlier this month, the Chennai bench of the NCLAT approved a settlement between Byju and BCCI. This settlement, which involves payment of 158 crore in arrears, would allow Byju to exit insolvency proceedings that were initiated due to a petition from the BCCI. NCLAT confirmed that the settlement had been reviewed by the Committee of Creditors and was deemed satisfactory. It was noted that the source of the settlement funds was transparent and that the interest of all parties, including Glass Trust, which represents the creditors, was preserved. But US-based lenders objected to the settlement, suspecting that Byju might use their loan funds to pay the settlement amount, essentially diverting their loans to pay off BCCI debts. Today, the bench led by CJI D.Y. Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra was hearing a challenge to NCLAT's decision by US-based lender Glass Trust Company LLC in appeal. The court stayed the impugned order and directed BCCI to deposit the sum of 158 crores in a separate escrow account till further orders. The Supreme Court has dismissed a petition challenging the decision of National Medical Commission to not hold NEET super speciality exam, that is the NEET-SS 2024 this year. The petition was filed by 13 doctors under Article 32 of the Constitution. The bench of CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra observed that the data given by National Medical Commission suggested that at least 40% of the students who take the NEET-SS are from immediately preceding batch. The bench noted that the petitioners who have appeared in the NEET-SS before would not be prejudiced if the exam is deferred to next year. However, if the exam is held this year, then the 2021 postgraduate batch students who would be completing their courses only in January 2025 would lose their chance. Therefore, the bench observed that the decision of the NMC is fairly equitable and cannot be termed as arbitrary. Though the bench agreed that the delay in the exam will cause some hardship to the petitioners, such hardship has to be balanced with the other concerns raised by the NMC. At the same time, the bench accepted the petitioner's prayer that the NMC must take an early decision on laying down the schedule for NEET-SS 2024 exam. So it directed that the schedule shall be announced not later than within a period of 30 days from today, factoring in the number of students who would be completing their PG courses in January 2025. The bench further directed that the exam be held within 3 months from January next year. In the next update, the Supreme Court today stayed coercive proceedings against YouTuber Savukku Shankar in 16 FIRs filed against him over an interview that he gave on a YouTube channel. Shankar, an independent journalist and YouTuber, was arrested on 4th May this year for allegedly making defamatory remarks against female police personnel during an interview with the YouTube channel Red Pics 24/7 on 30th April. Following this incident, a total of 16 FIRs were filed against him in different cities of Tamil Nadu, all stemming from the same interview. In July, let me tell you, the Supreme Court had ordered his interim release from preventive detention, which was subsequently quashed by the High Court. Advocate Balaji Srinivasan, appearing for Shankar, informed the court that after the Madras High Court set aside the preventive detention of the petitioner in August, he was detained again yesterday under the Tamil Nadu Preventive Detention Law. The bench comprising CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra has issued notice in the writ petition to quash the FIRs against him. The court has also stayed the proceedings against him arising out of these FIRs. In the next update, the Supreme Court today issued notice on Tamil Nadu Minister Udhayanidhi Stalin's plea for clubbing of criminal cases registered against him across multiple states over his controversial Sanatana Dharma remarks. The DMK leader and son of Tamil Nadu Chief Minister M.K. Stalin came under the scanner in September last year for his remarks comparing Sanatana Dharma to diseases like malaria and dengue, while advocating for its elimination on grounds that it was rooted in the caste system and historical discrimination. This not only triggered a major political row but also led to several criminal complaints against Udhayanidhi, besides pleas being filed in the Supreme Court seeking action against him. During the hearing today, the court was informed that a total of 3 FIRs and 5 complaints have been registered against him. The Respondents' Council raised a preliminary issue saying that there is a specific provision under Section 406 of CRPC, that is, the power of Supreme Court to transfer cases and appeals, and only the FIRs could be clubbed and not the complaints. A bench of Justices Sanjeev Khanna and Sanjay Kumar heard the matter today. It orally expressed that the cases will have to go outside Tamil Nadu. The names of cities and states of Kerala, Bangalore and Patna came up during the hearing for the trial of the cases. The bench briefly considered Bangalore to be a good prospect when it was pointed out that a case was already pending there. However, doubts arose when it was highlighted that the case in Bangalore has been stayed. The court has issued notice today and has exempted Udhayanidhi from personal appearance. In an important news, the Supreme Court today designated 39 advocates as senior advocates. If you recall, in January, the Supreme Court conferred senior designation on 56 advocates. This was then followed by 5 senior designations conferred in March. Senior designations took place in the Supreme Court this year after a gap of 5 years. Further, this year is also the first time that senior designations have been decided based on the modified guidelines framed as per the judgment passed by the top court last year in its 2017 judgment in Indira Jaisingh versus Supreme Court of India. To read the names of the 39 newly designated advocates, you can visit livelaw.in. The Delhi High Court has today issued notice to BJP MP Bansuri Swaraj in the plea moved by Aam Aadmi Party leader Somnath Bharti, challenging her election from New Delhi parliamentary constituency in the Lok Sabha polls 2024 on the grounds of corrupt practices. Bharti alleged that Swaraj's agents distributed pamphlets with her details, including PM Modi's photo, at polling booths asking voters to support her, which he claims is a corrupt practice that misled voters and influenced their decision. The court, however, today removed Rajkumar Anand, a Bahujan Samaj Party candidate, from the list of parties in the election petition. Bharti had alleged that Anand was planted by the BJP to split votes and help Swaraj win. However, the court found that even if Anand's 5,269 votes had gone to Bharti, he would have lost. The court also considered removing the returning officer as a respondent, but Bharti's lawyer argued that his presence might be necessary for preserving election records. Significantly, the Calcutta High Court has directed that benefit of childcare leave must be extended to both male and female employees, and family responsibilities must be shared by mother and the father. Justice Amrita Sinha was considering the case of a man who had 2 minor children and had lost his wife a few months ago. His children are of school-going age and there was no one to take care of them apart from the petitioner himself. To take care of his children and for their physical, educational and emotional development, he intended to avail the benefit of the child care leave. It was stated that according to a memorandum from February 2016, the government of West Bengal introduced the paternity cum child care leave for 30 days in respect of male employees. The petitioner contended that 30 days would not be enough for him to take care of his children. He referred to another memorandum from July 2015 where the benefit of child care leave has been extended to the regular female employees for a maximum period of 2 years, that is 730 days. He contended for the same to be extended to him as well. The council representing the state respondents submitted that the benefit which had been granted to female employees was not available for a male employee. It was stated that the representation of the petitioner in this case was pending consideration and that the same would be considered in accordance with law. The court, however, directed the relevant state authorities to consider providing parity in child care leave for both men and women. It further directed that a decision in the petitioner's case here shall be made within 90 days of the order. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.